Hello, this is Sundeep Bhatia of Beaumont's Law Practice Solicitors, and today I want to talk to you about two things which don't mix very readily, namely driving and drinking. Cheers. So anyway, as most of you as drivers should know, if you drive a motor vehicle on a public road in this country, and if the level of alcohol in your breath, if you're stopped by the police, is over the legal limit, then you will have committed an offence of driving with excess alcohol. Now, if you are unfortunate enough to find yourself under investigation for this matter, what is likely to happen is that the police will stop you whilst you are driving your vehicle because they're concerned about the way in which it's being driven. And they'll pull you over to the side of the road. They'll ask you to get out of your car, and they'll take or attempt to take a roadside breath specimen, and they'll give you a contraption, a small contraption to blow into. And if that indicates at the roadside that you are above the legal limit for the amount of alcohol in your breath, then you will be arrested and you will be taken to a local police station where another couple of breath specimens will be taken on a more involved contraption, which is known as an intoximeter. And dependent upon the level of that reading, you may find yourself in a situation whereby if the breath specimen is over the legal limit, you are charged with the offence of driving with excess alcohol. If it's below the legal limit, then you would not face any action. And there's a bit of a never land where if you're slightly above the legal limit, you may be given the option of having a blood sample taken from you, in which case you would have to wait for a doctor to come to the police station to take a sample of blood. You would then be bailed out of the police station to come back again once that blood has been analysed. Now, if you find you're slightly above the limit and you're given the option of blood, there are two schools of thought. One is you might as well have the option because there's going to be a delay whilst a doctor comes out to take that blood specimen. But one of two things can happen whilst you're waiting. If you've been drinking just before you are stopped by the police, then your alcohol level in your blood may be going up, in which case it may be a higher reading when the doctor comes than it was at the intoximeter. However, if you've drunk sometime before you're stopped, it may be the case then that the level will be going down, such that it may be below the legal limit when the blood sample is taken. But whereas a breath sample is instantaneous and you can know the result there and then at the police station, there's a delay whilst blood is analysed, and there is another option of urine being taken, and there's obviously will be a delay whilst that is being analysed. So let us assume that you are charged with an offence of driving with excess alcohol because either the amount of alcohol in your breath is above the legal limit, or the blood sample comes back and you're still above the legal limit or the amount of alcohol in your urine, then you'll be charged with an offence of driving with excess alcohol, and in most circumstances you would be bailed, in the sense that you'd be released and given notice of a court date when you need to go to court, and where you would face the charge of driving with excess alcohol. So in some cases, if someone is likely to commit further offences, perhaps they've got several drink drive matters, or because there are other aggravating factors, then bail might be withheld and the person might be held in custody overnight to go to the next available court. But let's assume that you've been bailed and you go along to the court on the day in question. You would then face the charge of driving with excess alcohol, and you'd be asked to indicate whether you wish to plead guilty or not guilty. Now, if you are charged with driving with excess alcohol, you have an option of asking for the services of the court duty solicitor for the first appearance. The court duty solicitor could be anyone from a local firm, and they may have one person to see at court that day, or they may have 10 people to see at court that day. So it's very much the luck of the draw, who you get, and the level of advice that they can give you. The other alternative is obviously to have someone attending who you choose to attend. And if you wanted myself, or if you wanted me to arrange for someone to come on your behalf, obviously I could do that. But the first thing to say is that if you plead guilty to driving with excess alcohol, or if you are found to be guilty of driving with excess alcohol, then you are almost inevitably going to lose your driving license, because it is what's called an absolute offence. In other words, the fact that you thought you drunk less than you did, or something like that, it's not a defence. So if you plead guilty or are found guilty, regardless of the job you do or the circumstances of anyone who relies on you because you have that driving license, that's not going to save your license. The only arguments that can be made to save a license in circumstances where you've pleaded guilty or found guilty is if there are special reasons for not disqualifying you. And that may be, for example, because you were driving because there was a medical emergency and there was no other option, or because your drinks were spiked, you were unaware they'd been spiked, and therefore you drank without knowledge. In those circumstances, there would need to be a trial to find out whether those matters applied. And if special reasons were found to apply, then a court has a discretion. It may still disqualify you for the full term it was going to in any event. It may disqualify you for a shorter period of time, or it may not disqualify you at all. But it's a very, very high bar to reach to establish special reasons. So in the majority of cases, if you plead guilty or found guilty, you're going to be disqualified, and the length of the disqualification will depend on the reading of alcohol in your blood, or in your breath, or in your urine, whichever is applicable. And the court has sentencing guidelines. The minimum period of time that you can be disqualified for is 12 months, which will be for a very low reading, just above the legal limit. And it rises upwards depending on the level. And if you're more than 3 times over the legal limit, then you could be a danger of receiving a prison sentence. But otherwise, the normal punishment is disqualification, a fine, dependent upon your means and earnings. You'd fill in a means form. But one useful hint is that if you're given the option by the court, you can do a drink drive rehabilitation course, which would reduce the length of the ban by some 25%, providing that you complete the course by a specified date. So if you find yourself in the unfortunate situation of being charged with driving with excess alcohol, then do get in touch, and I can come down to a court, one of my colleagues can, or an agent on our behalf, and we can see what we can do to improve the situation for you. Thank you for listening. That's Sundeep Bhatia of Beaumont Law Practice Solicitors. Our website is www.beaumont-law.co.uk, and I look forward to hearing from you, and thank you very kindly for listening to this video. Good day.